Thank you, Andrew. Yeah, I'm just going to start off with a bit of a sort of a history lesson about disputes in the process industry. For those of you practicing in the early 90s, it was the case that the process industry had very few disputes. And it was for that reason that they set up a lobby group that persuaded Latham and those enacting the Latham reforms to exclude the process industry from the statutory adjudication scheme. And the reason for that was the process industry said, well, we don't have a problem with disputes, therefore there's not something that needs rectifying, please don't impose statutory adjudication upon us. And then, so the question is, well, why historically were there fewer disputes? And I was thinking about, well, why was that? First of all, in the process industry, there's a much smaller pool of contractors. It's a very specialist industry. There were less contractors, and there was less appetite to fall out with a smaller number of employers. You know, you had the likes of BP, Shell, ICI. There were a small number of major players and a small number of contractors, and they just didn't want to fall out with each other. Secondly, there were a lot of reimbursable contracts historically, and by that I mean you're paid by the hour. And if a contractor's paid by the hour with a margin, if the project overruns and it takes longer, the contractor still gets paid. So there's no real dispute at the end. There's no sort of risk being held by the contractor. Another reason is that the production losses on process plants tend to be enormous, and they quite often dwarf the capital costs of the project. And therefore, there's an interest in getting the job completed rather than having an argument and a delay. So the employers would often effectively bankroll out any delays to get the project finished. And of course, if they're paid for that delay to be brought out, there's no dispute. Rarely payment issues, because the likes of BP and Shell have enough cash, whereas if you have a civil construction job that's funded, you know, there can be funding issues, and the employer sometimes runs out of money and uses the contractors as a sort of an informal bank, but you don't get that in the process industry. So that's why historically, in the 1990s, there weren't so many disputes. So the question is, well, has that changed now? And here come my interesting statistics. They're not that interesting, by the way, but they're worthy of note. So I've had a look at the appointments that the ICME makes sort of over the last few years in terms of the different types of appointments when they're asked as an appointing body. And of those, 81% are adjudication appointments. And that's quite a surprising statistic, given that statutory adjudication is excluded from the process industry. The next highest was expert determination at 12%, arbitration at 6%, and dispute boards at 1%. So if you take out the statutory adjudication, expert determination is the sort of most prevalent form of dispute resolution. And that's always been within the ICME forms of contracts, and it's a commonly used tool within the process industry. And that still is the case, and I think is one of the reasons why there are less disputes. And Philip's going to talk about that in a moment for those of you not familiar with it. In terms of the changing environment, certainly in my experience, there are now more disputes in the process industry. And I think there are a number of reasons for that. First of all, there are a much larger number of smaller projects. So, for example, I see a lot of biogas projects and things like this. They are process-type projects, but they are all funded by one-off special purpose vehicles which have a funder in there. There might be a local farmer, it's a small plant, it's new technology, a small contractor. And if that goes wrong, there will be an argument. They're lump sum contracts. And again, yeah, more lump sum contracts, more target cost contracts, and with those, there's a risk, there's an allocation of risk to the contractor, which gives rise to more disputes. A lot of performance issues now, and I think part of that is, again, refineries, that the technology evolved over many years and many decades. And if you're operating a refinery and want a particular new process unit put in, you went to that contractor who had 30 years of experience of installing these, and all the defects have been ironed out way back when. Because a lot of projects now, it's all new technology, certainly in like the waste industry, where you get a lot of gasifiers. A huge number of gasifiers are all put in at the same time, all with the same technology. And if there's a mistake in that technology, which there inherently generally is, then you get a lot of disputes on all the projects at the same time, rather than an evolution of the technology. And finally, another area where I see disputes is actually joint ventures. Again, 30 years ago, contractors were quite big and they would take on a whole project themselves. A lot of contractors now form joint ventures to effectively implement some of these mega projects. And you don't necessarily get a dispute between the employer and the joint venture, but you get disputes between the joint venture parties. So I think the scene is changing. There are more disputes. However, just bear in mind, those statistics I gave you in terms of the number of appointments, they represent a fraction of the number of appointments that, for example, RICS make per year. It's like less than 5%. So on sort of the data we have, the number of disputes in the process industry is still much, much less than other industries, but I can see it creeping up.
So you mentioned new processes. If things are settled by ADR, how does that help the other projects which use the same processes?
Yeah, I mean, that's a tricky one, because if you have a dispute that's in the High Court, you often get a decision on the process. So I acted on the MT Hogarth case, which was the fitness for purpose case about wind farms. And that was one of the few contracts that had a court clause in. And therefore, you got a court decision about the fitness for purpose obligation and about the defect. So everybody could see it. And that's an example of a technology that was prevalent because they built wind farms really quickly all at the same time. And they all had the same problem with them. So that was across the board. And you're right, with ADR, people don't know, because if you have private dispute resolution, you don't know what anybody else is up to. You don't know whether it's just your project that's got the same problem or other projects. And if you get a negotiated settlement, you really don't know what everybody else has agreed. But of course, you know, in some ways, well, that's the advantage, because in our sort of industry, you don't necessarily want to sort of effectively wash your dirty linen in public. People don't want these disputes aired. They want to do a deal, they want to settle, and in fact they want to settle on terms such that the project is fixed in working so that the technology can be used on subsequent projects. So I think there's more of a will to try to fix it because it's technology that can be sold, whereas, I don't know, if you're on a civils building, if you're building an office block, you just build office blocks, they're all different, but it's civil work. It's you know, if there's not the same technological issues. So
that's the key point. These parties don't want their dirty laundry out there. And all these decisions, and whether it's arbitral awards or whatever, they're generally private. You never get to know what's going on.
Yeah.
So the answer is dispute resolution generally won't feed forward to further disputes because you just won't know what other people have decided.
What about selection of the whatever the dispute process is? If you've got a neutral, if it's a mediator or an expert, should you always pick the same one? How do you know who the right one is?
You don't know is the honest answer. I've been involved in a lot of the smaller projects that Paul's talked about that have gone wrong, and on the whole, because you've got the anomaly of the exceptions, people aren't always clear on their project, what's inside, what's outside. So then they're putting in contractual adjudication. Then the problem is, who are they using as the A and B? So, for example, there was a gas to grid project, which was basically burning, purifying methane, pumping it into the grid. And there they used an NEC contract, but they used the ICME as the nominating body. So they did give some thought to who was most likely to have suitable people on their panel. But other times they don't. So, for example, if you've got a complicated process disagreement, you don't necessarily want someone from the RICS, but numerically they're the biggest nominating body.
yeah, I mean that's certainly the case. RICS, you know, huge number of appointments each year, and they are sometimes named as the A and B on process contracts. And you know, sometimes there are a lot of civil works, and you have perhaps a huge amount of the project is all the foundations of the concrete pouring, especially on these biogas plants. It's actually a civil engineering project, but there is some technology in there. And generally, the civil engineering's fine, and it's technology that goes wrong. But if you have a dispute, you might end up with RICS appointing someone. And that's where it can be problematic, because RICS, obviously, their list is designed for their particular industry, which doesn't necessarily marry with the process industry.
Yeah. If I might, my limited experience in process disputes, I've seen NEC form of contract being used quite frequently in process projects, which then introduces the W2, whatever the case may be, adjudication provision, condition precedent to going on to the tribunal. So I think that, there is the, potential for a contractual adjudication or arbitration or court with these sorts of projects. But in my experience as representing parties, not on a process dispute or petrochem, but in the petrochem industry, where you're building offices and the like for oil companies, as Paul mentioned earlier, the industry is awash with money, and so they could just throw money at it. So you'd have a dispute brewing, and then you'd negotiate a pretty decent settlement usually, just to avoid the dispute because of the potential for losing production.
Actually, I was going to raise exactly the same point about the free availability of cash, and it may be that because of the nature of my job, I've only come across areas where people aren't prepared to splash their cash to get rid of it. But I have come across governments who are not prepared to splash the cash because it's public money, has to be accountable. But I've come across the same thing in large entities where there's a budget and where there's a difficulty in identifying someone who's going to take the risk of putting their name to an amount which has to be paid. Particularly in the last panel, they were talking about where you have rotating management responsibilities, and someone's aim might be to survive without having committed to anything. Is this not an issue in the process world?
Well, just building on what Paul said earlier, the IKME panel, for example, it's not a volume panel. But when they do come along, they're juicy. But I've been on the panel. In fact, Paul interviewed me 10 years ago. And I've been on the panel for 10 years. I've done 5 adjudications in that time. And every single one of them has been about money. But they've not been between the shell and the contractor. They've all been a contractor, the subcontractor. And that financial dynamic is very different. The contractor's under a bit of pressure, he's late, big LDs and so forth, and he's looking to get money off the subcontractor. So every one of the 5 disputes that I've dealt with under the IKME, they've all been highly complex sort of engineering issues, but all about money, and all between the contractor and the subcontractor, not that higher level up, where I don't think you see so many disputes because, to Paul's point, the money's there. It's that lower tier that I've seen where there's a real scrabble for money.
Yeah. I mean, so the statistics I gave you, I mean, I haven't analysed them to that level of detail, but I wouldn't be surprised if the vast majority of those adjudications are payment disputes at the contractor-subcontractor level.
All of mine were,
Mainly payment disputes. The expert determinations will almost certainly be technical, although Philip could tell you more about that. And same with the arbitrations. And also you have to be a bit careful with the figures. So I've been involved with a dispute on a tank farm. And on that one, I was acting for the main contractor, and we had 11 adjudications with one of the subcontractors who just went into serial adjudication mode. And sort of, every other day I come into chambers and there'll be a new adjudication started. So a large number, all small points. Whereas we then had an arbitration with the employer, and that was one all singing, all dancing arbitration where all the issues were canvassed in one go. So you do have to be a bit careful with the numbers, because certainly in adjudication is typically used to take small bites. So you do have large numbers of disputes, which would actually normally be dealt with in one arbitration or perhaps one expert determination. So the numbers are what they are, but just, you can only take so much from them.
Thank you. Thank you very much. So, Philip, if I can turn to you, you're going to deal with the case for expert resolution.
I'm going to whiz you quickly in, I think, 5 minutes through expert resolution. So it's got its attractions. It's consensual. It's not a statutory regime, but you can build it into your standard terms, or you can build it into individual contracts. It can be final and binding if that's what you want, and it tends to be quick and cheap. And focused on certain matters. But you can use it, I mean, I'm a legal expert, obviously, but you can use it for quantitative disputes, technical disputes, and legal disputes. it tends to be seen as highly specific, and this may explain why it's not so widely used, because if you're on a very large general engineering or building contract, Heathrow Terminal 5, for example, had 200 trades. How many experts would you need if you were looking for expert determination of very specific issues? The problems as I see it are with what I would call framing the dispute and then fielding the dispute. So particularly on the larger disputes where you've got very sophisticated legal firms and counsel, you've got to get a dispute often to a boffin, and you're trying to pin him down to deal with certain things. He's very interested in biochemistry or whatever. You're trying to pin him down to deal with certain things, and you can literally have 25 pages of this framing of the issue. So that's part of the question: is this going to work in practice? And the fielding, okay, you've got him to a point where he's making a decision, but what is the significance of that decision? If you found this, then what are you going to do? You want to direct the expert as to what he's going to do about costs and interest and his fees and so on. So if you're looking to put together an expert determination procedure, I've looked at three possible approaches. One is the IChemE, which obviously for this sort of stuff is probably what you want. But the IChemE White Book is very specific and drafted to fit in with individual contracts such as the Red Book or the Green Book. And you need to bear that in mind. It's highly specified and dovetailed. Then there's the RICS professional guidance. They haven't got rules, but they've got their own professional guidance, 46 pages of it, which is well worth looking at. And then, just because it's so up to date, the Academy of Experts rules for expert determination 2023 split into a set of general rules and principles and then procedural rules. So as I say, the IChemE White Book rules are to be read with specific standard forms of contract and have very specific provisions. Those particular contracts have very specific provisions about what can be referred to an expert. Although, and this may be a takeaway for you, the parties can always agree to refer disputes to experts, so that is there. The White Book is well written. It's a specific set of rules for expert determination. It's short, it works well, it's got guidance notes which are sensible, and if you are the expert, then you've got a number of annexes with it which give you the terms of appointments, whether it's an appointment by agreement or an appointment by the president of the IChemE. So if I was going to dovetail a set of rules based on the IChemE, then I think I would use the White Book clauses 8 to 12, which deal with these things. There's a procedure for investigation, a procedure on appointment, what happens if you settle along the way, and then the powers of the expert, which I'll come on to, and then rules for decisions, which include that the expert can order provisional relief, which is always useful. So the expert can order money, he can order interest, and he's got this arsenal of things then that he can do. So he can order a party to do or refrain from doing certain things. He can make a declaration. Importantly, he can rectify or set aside or cancel documents, which is a very important thing. He can decide his own jurisdiction, which stops lawyers messing about. He can decide his own jurisdiction, and under Clause 12, he can make more than one decision on different issues at different times. So I commend the IChemE rules, particularly the White Book, to you. The Academy of Experts has got an up-to-date set of rules, easy to understand, easy to incorporate, split into general rules and principles and specific rules. It's got a clear, fast timetable, a final and binding decision. It's got a slip rule, and it provides the time for payment if a payment is awarded, deals with costs and interest, also a sort of peremptory order system of unless notices, and you're not, as an expert, bound by the rules of evidence, which I think is quite important, particularly for technical experts. Not so good features are that there's a pretty complicated system of appointments where the Academy nominates up to 3 experts. I won't run through that, but it's a complicated system where the parties have the right to object, and it makes it more complicated than it needs to be. A party can object to the first nomination, and then it's just taking time to get through it. And really the main downside is not knowing what you might get when you launch the process. One of the rules, 5.2, states that the expert shall adopt procedures suitable to the circumstances of the case. That's okay. There's a specific timetable under Rule 8 for submissions. That's okay. But then under 5.11, the expert of his own motion has discretion to amend the time limits and amend the procedural rules. So he can basically go back and do pretty much anything. And also you can have cross-claims, and where you've got a dispute and then cross-claims, it all starts to get fairly complicated. The RICS, as I say, doesn't have a set of rules, but it's got this guidance. It's well worth reading. It's detailed, it's thoughtful, and just have a look at it if you're thinking of putting together your own consensual expert resolution system. Just bear in mind, if you're looking at the RICS, the majority of expert appointments are under rent review disputes, which sort of skews things a little bit, and the rules are a little bit subjective. For example, you've got this one that says there will be no need for the independent expert to meet the parties, and to do so would waste costs and cause delays. So quite 1 or 2 fairly subjective points there. Thanks very much.
That's great. Thank you very much. So I've got a couple of thoughts. What about fair process?
Well, I think what you might be getting at is I've had appointments myself as an expert. I had one appointment where I had to deal with waste, and it involved 4 local authorities, and it was a bespoke set of rules, and it said that you have to make a decision in 14 days. I made my decision in 13 days. I'm perfectly okay with that. You know, the idea, I think, is to make simple decisions with simple, clear reasons. There is a school of thought, I don't want to provoke too much, but it's arbitration has been infected with an unnecessary legal sophistication, and some would see the expert process as an antidote to that. So I don't see it as a particular problem, but there may be situations in which you would have to ask for more time.
Can I say something into that? I mean, Philip's example of 14 days, that does sound ambitious for a decision. Like under the IKME rules, there is, although it's meant to be quick, cheap, effective for expert termination, there isn't actually a deadline for issuing the decision. So, you know, the expert termination might, typically they do take a month or so, but they could take 2 or 3 months. There's no deadline. The second issue is, of course, it's consensual because the parties agree to expert termination. So if you're agreeing to that, you're agreeing to the process, and you're agreeing to the slightly, not rough and ready, but you're agreeing to be bound by it in that way. So nobody's forcing you to do it, so there's less scope for due process arguments to come in if the parties are signed up to it.
Well, do both parties really have a choice about those terms? Doesn't the more powerful party produce the terms and say, you want to work for me, you sign those?
Yeah, but unless the contractor has a gun to his head, he doesn't have to sign the terms. Well, I say this a lot to contractors. Well, did somebody have a gun to your head when you sign this? No. Well, you're bound by them.
I mean, I think that's an obviously understandable and quite correct legal view. I think to have commercial people say, well, of course I had a choice. I could work or not work. You know, I've got children at home and I've got to feed them. And, you know.
Yeah. No, but don't forget though, it's not that I mean, say for Philip's example, of course, the White Book is written as it's meant to represent best practice in the process industry, and on our panel we have a mixture of employers, contractors. Therefore, it should represent a balanced view, and by signing up to those terms, theoretically, you shouldn't be being coerced into a set of very unfair sets of conditions. That might be different, obviously, if the employer changed the terms and conditions and put in extra provisions.
Can I throw in just one last quick point on this? So there's a power to rectify, set aside and cancel, presumably agreed provisions to anticipate something that's coming up, say a dispute about a specification, and you go, all right, that bit, we'll cross that out and we'll just use the other bit. And it's final and binding.
Yep. Well, it is final and binding. There are very limited grounds for challenging expert decisions. A lot of people say, well, that's the advantage of it. If we've got a very narrowly defined dispute, we just want an answer to it, and we'll live with the answer. We don't want this to run on for ages. So, I mean, typical example for me would be, I was involved in one where there was a metering skid, and there was a dispute as to how you calibrated it. And you don't want to go to arbitration for 2 years to get the answer to that. So that went to an expert, and party A said, you calibrate it using these figures and in this way, and party B said, no, you use these figures, you use this formula, and use this code. They got an answer, final and binding, and that was it, and then that was how you calibrated the meter. And it sort of diffuses things as you go along. But ultimately, it's consensual. If you sign a contract and that's what you want, if you don't want it, you can strike those terms out.
Donny's got a comment, then we'll move on.
Can I also just add on to that, Andrew? The example you gave, Philip, the expert has jurisdiction to determine his own jurisdiction. He's got the power to do that. Again, it's quite a sweeping power. You know, final and binding, end of, no appeal. It's a difficult problem. But as you say, Paul, the ideal is for it to be on a short, simple, sweet topic.
Yeah.
And that's how you can do it in the 14 days. Unfortunately,
Well, not always 14 days. I think Philip's at the extreme there.
My experience has been, you know, never been simple, single topic. Yeah. It's usually a morass. Sometimes people, you know, contracts are made for construction. I digress from the Petrochem aspect just now, but in construction, you occasionally come across these expert determination clauses with 14 days, and it's a kitchen sink, arbitration style kind of claim, and there's absolutely no danger you can ever do that in 14 days, you know. So, but I think it's something, it's a process that I love, you know. I just love expert determination because of the power that the expert has.
I think, you know, from a control freak's point of view, it makes me really nervous because you give all this control and power to someone else, and you say, right, that's it.
But very often when you're negotiating these contracts, things like the termination provisions and the ADR provisions, they get left. They don't get dealt with. And it's all the never, never. You know, you concentrate on getting the job and winning the job. You don't want to talk about the ADR very often. And most contracts I get involved with, the parties have agreed to some complete rubbish in many cases, and they just haven't thought about it. And they don't think about it until the adjudication lands, and they can't adjudicate because of Section 105 or whatever. They just haven't thought about it.
So I'm going to ask you to keep on talking now, because you were going to talk about specifications and the types of disputes. So.
Yeah, I was just to focus on, with my sort of various chemical engineering hats on, the sort of disputes that I've been most involved in. And one of the key issues, and I think one of the key differentiators between process contracts and other forms of contracts is the performance specification. That is key to process contracts. What is it the contract is there to deliver? And it's usually defined and narrowed down very closely to a small table. We used to call it the devil's table in my previous career as an engineer, where that was where the data was. That's what you had to achieve, whether it was a power generation or water recovery, whatever. And that was the issue. So I mean, the IKME contract deals with this very much. The process specification is key. The next thing is, how do you test and confirm compliance with that performance specification. The third thing is what happens when the proverbial hits the fan and you don't achieve it. If obviously you do achieve the specification, you get takeover, handover, call it what you will, but if you don't achieve it, what happens? And you're normally staring at the wrong end of termination provisions. And the first time I got involved in this, I was an engineer. I hadn't really got involved in disputes. It was the late 90s, and I was the engineer delivering a project in the food industry. And I hadn't designed the process, somebody else had, but I was designing the actual build and taking it forward to the process trials and so forth, which took probably a year. And the contract had been negotiated by clever people and contract drafters over 2 years. And the devil's table, the one table that said what we had to achieve, was really only 1 or 2 lines. And that line was process recovery. What did you have to recover? It was protein material. I won't say what the food stock was, but it's something that you might love or hate, if that's a clue. And you wouldn't like it too much if I told you how it was made. But there's a pigeon story which I can tell you later on, where a bunch of pigeons grew in the feed material, and we had to pick them out before we processed it. But take that to one side. We had to recover 97%. Now, all the clever people drafting the contracts, the lawyers and so forth, hadn't actually troubled themselves to say what 97% actually means. And this was critical. And I'm sure all the room would agree, 97% means 97 somethings out of 100 somethings, but what was the somethings? And the somethings was very clear to the employer. It was also very clear to us, but that clarity was different. The employer believed that was on a weight per weight basis. For every 100 kilograms coming in, we'd recover 97% of the valuable protein materials. And we designed it on a volume by volume basis. Now, those two things aren't the same. Now, they are linked because weight and volume is linked by density, to a bit of basic physics. But those two things weren't the same. So when I rather cock a hoop ran the process trials and said, I've reached it, I've got 97%, 98%, sorry, the employer said, well, no, you haven't, you've got 96%. Because we were talking about different units. And the employer actually, I think, was probably right in the end. They proceeded on their investment as being weight by weight. And whilst 1% we were adrift, might not seem an awful lot, on a worldwide production scale, that was a lot of money. And the termination provisions were very clear. You've got several bites of the cherry with the performance trials. If you don't achieve that, you're terminated. And that's what happened. We ran the trials. I thought we'd hit 98. They said no, it wasn't. And they terminated us. And you can imagine what happened next. We said, oh, that's a repudiation and so forth. But we went to expert determination on that point, on a very narrow point of what is the correct unit here. And we lost, which was a shame. And we went forward to arbitration. But the party settled, and I don't know what the terms were, but our plant was basically removed, and the factory was reinstated. So that would have cost millions.
So let me just ask a question. Say the expert referral had said, we dispute the validity of the termination.
Yeah.
Not what was the correct calibration for that test.
Correct. Yeah, we ballsed it up. Basically, we asked the wrong question. What we should have been dealing with is was this termination valid, and then opened up a number of issues. But we went to expert determination and asked a very specific question, and it was an important question, but it was only really a part of the overall dispute. So that's my point. Effectively, is that in that process field, generally you distill down to a very small number of key issues, and they are critical, and how you're testing them is critical.
Yes. Okay. So I'm not going to ask any questions on that. I'm going to move on to Donny, who's going to talk about adjudication and particularly dispute boards.
Yeah. Okay. So one of the when I was thinking about what I would say here, looking at the ADR processes that might be appropriate for Petrochem and Process, what's the difference between what I'm most familiar with, which is construction and civil engineering, and these kinds of projects? And as Paul mentioned, the capital cost of a Petrochem process plant is usually a much smaller value than the actual production benefit from it. So usually the production is paramount. You know, employers want to get production, get the product out, whether it be oil or pharmaceuticals or food or whatever it is. That's where they make their money. So they also involve aspects that are very niche engineering, chemical engineering or mechanical engineering that may not be familiar to most practitioners. So looking at that, how do we get a good process for it? We spoke earlier about dispute boards, and my experience in dispute boards is that they are the bee's knees. They work really well, and they afford the parties the opportunity to have a mix of technical and legal experts deciding a dispute. And not only that, if a dispute board has been constituted as part of the project, it's a standing board that's there from day one, it has regular meetings with the parties to it. It is there to follow the project. It can understand when problems arise. It knows the background to the issues, and it can very often assist in resolving these disputes before they get to be a dispute, you know, so the likes of the conflict avoidance aspect that is prevalent in most dispute adjudication boards. And then again, if you know there is a problem that is intractable, then it has the facility there with the background knowledge it's developed over the course of the project to adjudicate and give a temporarily binding but normally finally binding decision on any particular dispute that arises.
Can I just
certainly.
ask a question there? So what we heard earlier is that people at the top have more money than they need, and so they have available funds to settle things, subject to the developing smaller companies, as Paul was mentioning. So that doesn't seem to be where all the disputes would be, but that's where you'd put the dispute board, because it would be in the original contract.
Yeah, you could have a dispute board in a subcontract too. Of course, there's nothing to prevent that. Occasionally, you could have a dispute board that can cover both the Tier 1 and Tier 2 subcontract issues, so that you can get a cohesive answer to the problem. You can join these disputes. Very often, a main contractor, Tier 1 contractor, wants nothing to do with the dispute. You could have a specialist subcontractor who's got a problem with the specification that the employer has produced. Nothing to do with the main contractor. Rather take a back seat. So that facility is very beneficial to Tier 1 kind of contractors.
Mm-hmm. Internationally, though, DRBs are mandated for in the IKME forms, aren't they?
Well, optional. It's not mandated.
So parties have to opt in.
Yeah, it's in there. That's how the DRB rules that we have kicked off. It was when the international forms were issued, DRB was put in as an option, mainly because it was anticipated that the contract would be used on the larger projects, and it's larger projects where it's more cost effective to have the DRB. And under the IKME rules, it's a recommendation board rather than adjudication board. I know you can flip around the terminology. So the default under the IKME rules is the dispute board makes a non-binding recommendation that the parties can adopt. Whereas I know a lot of other bodies and contracts and FIDIC, you have a decision that's binding unless you do something about it. So it flips it around. We took the view that if it's a binding decision, it ups the ante and people start turning up at the dispute board with lawyers, and then you're almost inevitably into a dispute. Where if it's a recommendation, it can be dealt with more at a project level, and quite often that will diffuse it and deal with it. Which is, as Donny was saying, if it's a recommendation, the dispute board's in with the process, it's in with the people on the ground, and hopefully is diffusing and giving advice that people can follow and can work their way through, rather than making a decision which one party doesn't like. Yeah. But yeah, it's only on the big projects, that's the problem. But,
If I might make one final point on dispute boards, there was a survey done by, I think it was the Florida Department of Transport 10 years ago, and they had 75 contracts over the period of a year, and they analysed them in terms of those projects that had dispute boards and those that did not. And the findings that they had from this was that the projects that had dispute boards, there was about 2% of those projects had time overruns compared to 20% of those that did not. And when it came to cost, there was about 12% of the projects had cost overruns with dispute boards in them, and those that did not had an 18% incidence of cost overruns. So there is, the dispute board itself is usually a very, very small fraction, 1% or thereabouts of the capital value of the project. So there's a real cost benefit to be obtained from having independent oversight from day one of the project going all the way through that can issue recommendations or decisions if necessary and so on.
So I'm the DRBF UK
You are indeed.
representative, and I fully endorse that because I have to, but also because I believe it to be true. Thank you very much